Thanks, Paul. And here with us now is Lindsay Berg, Director of the Center for Education Policy at the Heritage Foundation. Lindsay, it's good to have you this evening. How did today's ruling level the playing field for religious schools and institutions?
Well, today was just a huge win for both families and the Constitution. The court held that excluding religious schools from Montana's school choice program was simply unconstitutional, and that free exercise means that you cannot discriminate against people just because they are religious. So this was really just a huge win for families, a huge win for school choice, and a huge win for the Constitution overall.
Lindsay, what does this do for the school choice movement overall and the possible expansion of voucher programs throughout the country?
Well, the bottom line really is that states can no longer, under the federal Constitution, prevent parents from choosing religious schools if they are participating in a state school choice program. So for states that have school choice programs in place, they must allow private religious schools to participate. That is now guaranteed to be an option for a family if a state operates a school choice program. So this really means at the end of the day, families participating in private school choice programs have the entire range of private schooling options available to them. And this is really critical because we know that families often choose schools based on whether or not those schools align with their values. So this was really an important step forward to acknowledge that private religious schools, which are often what families are looking for when it comes to that values alignment, are still part of the overall options that are available to them.
So critics, Lindsay, of today's ruling say Montana's no aid provision has turned into must aid, forcing the hand of taxpayers who object to funding religious education. What do you say to that?
Well, first of all, Montana's program was a tax credit scholarship program, and that's really important and I think is getting lost in the conversation. A tax credit scholarship program, the whole way that it operates is through private donations to a private nonprofit scholarship granting organization that then provides those funding, those dollars to a private individual student to attend a private school of choice. So it is private from beginning to end and never goes to the hands of the government. That's an important distinction that often gets lost in this overall conversation. But the bottom line is this is simply neutral. If a state operates a private school choice program, they have to allow every option, the opportunity to participate, and cannot exclude schools, private schools, simply because they are values-based or religious-based schools.
Lindsay, real quickly here, the White House issued a statement saying states may no longer hide behind rules motivated by insidious bias to exclude religious schools from public benefits. The administration calls the fight for school choice a civil rights issue. Do you agree in about 30 seconds?
Yeah, that's right. And they're also right to identify the really sordid history of Blaine amendments. I mean, these were amendments that were passed in 1875, really to prevent the proliferation of private Catholic schools. And this is something that Justice Thomas recognized all the way back in 2000. He said that Blaine amendments were a doctrine born of bigotry and should be buried now. And this is why today's victory is really a big victory. It takes us one step closer to that goal that Justice Thomas identified over 20 years ago.
All right, Lindsay Berg of the Heritage Foundation, we will leave it there. Thank you so much for joining us this evening.
Thank you for having me.